Hello and welcome to another edition of No Nonsense with Pamela Wallin. Well, today we're going to look at the latest installment of Ottawa's legislation to control what goes on the internet. We've talked about this in various different forms, Bill C-10, C-11, C-18, which tried to impose new laws and on the relationship between traditional media and the online world. This one is about online harms, and the battle, the balancing act that everybody's looking for is, yes, we want to try to protect children from being either victims or observers of stuff they don't need to see, and how you balance that with free speech and protecting that. So we have with us, as we always do when this stuff happens, Dr. Michael Geist. He's a law professor at the University of Ottawa, where he holds the Canada Research Chair in Internet and E-commerce, and he's a member of the Centre for Law, Technology and Society. And we've spoken many times over the last couple of years on all of these issues. So now we're wrestling with this one, dealing with hateful or harmful content and wanting to do something about that, but trying to protect free speech. Welcome, Michael. Thank you for suiting up for this again.
Oh, thanks for having me.
Now, you have long said that of all of these bills to influence, control, restrain, constrain the internet, this one, online harms, was the one that troubled you most. Can you tell us why?
Yeah, no, it long did, and we'll get into whether or not those concerns were warranted or not. But, I think in many respects, the concerns, and you highlighted right off the top, real questions about freedom of expression and regulation online. And both of the prior internet bills, C-11 on broadcast internet streaming and C-18 on news, obviously had expression-related concerns, and I think in many ways those came to the fore. But this bill, as we waited for it, was clearly, I think, in many ways, the most directly connected to expression issues. So part of the concern was, well, just for that obvious fact that it's unavoidable that you're engaged in expression-related issues. The other element, quite frankly, was that the government's earlier plans, not a bill that dealt with the Human Rights Commission, but or Human Rights Act, but more particularly what their initial plans were for this bill, found in a consultation that they ran was in 2021, what raised a lot of red flags, created a lot of concern. And had they continued down that path, then I think that what they had telegraphed really would have been sort of the biggest source of concern.
So others have described this as a Trojan horse bill. And you say that there's actually 4 bills in one, which makes it really problematic. So let's just do that before we drill into what this might look like in the real world.
Okay, sure. And yes, I do think there are 4 bills, and one that actually can be neatly divided into 2 and 2. The majority of the bill, and frankly, the part that the government has gotten far better than we might have otherwise expected, we can talk a bit about why that might be, and certainly reflects some significant changes from where they were when they first started down this path, is essentially trying to carve out or identify the responsibilities of internet platforms when it comes to harmful content on their platforms. And so that is essentially the Online Harms Act, which is the bulk of this legislation. And then there's a smaller element that deals with mandatory reporting child pornography and tries to ensure that those same platforms are covered by those requirements in a way that internet service providers typically would be. And that is not at all a controversial aspect of the bill. So where the government stays with their focus on the responsibility of the platforms, what they ought to be doing, I think there's definitely room for improvement and some sources of concern, but I think they've certainly come far further and done a much better job than we might have otherwise anticipated based on what they previously been planning in their consultations. The other half of the bill, the other 2 bills, aren't directly involved with the platforms at all. They, in some ways, are more focused on what individuals can do or liability for individuals that engage in particularly harmful speech. And so those are amendments to the Criminal Code and amendments to the Human Rights Act that sort of open the door to some complaints at the Human Rights Commission. And I think those provisions have attracted much of the criticism and
Yeah.
controversy so far, and I think with good reason.
Yeah, absolutely.
Because they really do make some very questionable policy decisions. In some ways, it really is a separation where the government stuck to what they said they were going to focus on with the internet platforms. Really, for the first time in the three bills that they came out with something a bit more reasonable than what we had seen. But where they veer away from that, not so much.
And if they'd stuck to that and said, look, we're going to try and deal with kids and the impact on kids, but it's like they couldn't help themselves. They had to get back into the sort of controlling the internet side of things, right? Which you have to do on both, but just stick to the online harms and then try and work through the definitional stuff, which we will in a minute. But you've just been going through this in the last week yourself. You posted something and then it was taken down and then it was put back up and then it was taken down. So what did you say? Why was it taken down? Why was it put back up?
Yeah, so I think everybody's aware that since October 7th, we've seen just almost unimaginable, certainly unprecedented, at least in my lifetime, amount of anti-Semitism taking place in communities across the country. And I'm part of the Jewish community and have felt that it's been important to speak out and call attention to these incidents so that ensure people are aware that this is happening. It's a community that feels unsafe, and I think with good reason, and that many of our leaders just have not been stepping up in the way that we would have hoped, and it's been incredibly discouraging. I've been engaged in some of those posts. I posted something that involved some very clear anti-Semitic graffiti posted at a Toronto bus stop, and obviously, in some ways, it's not unusual. There are many of those kinds of things that have been happening, but the post or the graffiti itself and the anti-Semitism really struck a chord. It was kind of along the same sort of language that we saw back in the Holocaust, and frankly, just never thought we would see here. So anyway, I posted it.
We're seeing these signs literally, and in case you've missed this, I don't know how anybody would, but it says things like "kill Jews." I mean, it really does. This is not just some sleight of hand here. This is stuff that is illegal under the law right now.
Yeah, no, this is real and it's serious. These threats are very real, and people don't feel safe. They don't feel safe,
right?
Sending their kids to schools or in their synagogues or in their community centers, and it's the sort of thing that, frankly, I feel that that leaders at the federal level, provincial level, municipal level, if this was happening to many other groups, we simply wouldn't stand for it. But for some reason, they've been very slow to act here, and it's or have not acted with the kind of aggressiveness and in terms of ensuring that the law is appropriately enforced and ensuring that people feel safe.
Look,
doesn't mean you can't protest, but some of what we've seen, just to my mind, has really.
They just shut down a meeting between two G7 leaders, the Prime Minister of Canada and the Prime Minister of Italy, because nobody seemed able or willing to just have the cops come in and move this. Like that, to your point, that the reaction is so muted. Anyway, carry on with.
Yeah, no, it's to me, it's been incredibly discouraging. So in any event, I posted this first on Twitter, and of late have been posting some of the stuff on LinkedIn. It reaches a bit of a different audience. And to my surprise, LinkedIn initially sent me a note that the post had been taken down, probably within about an hour. And it was pretty clear that this was a machine-generated review, and without looking at the context, because I, of course, had provided a description how these images really brought back sort of thoughts of literally the Holocaust, which my grandparents were survivors of. So, it certainly sort of brought that to mind. LinkedIn takes it down, and it's saying that it violates their policies. And there's an option to file an appeal. I filed an appeal. It goes back up, but then again, some hours later, it comes back down again, and saying that, no, we've reviewed again. And in fact, it doesn't involve our hateful conduct provisions or guidelines. And, and I thought that was the end of it.
Yeah.
With several days later, I got an email from an executive there, someone involved in these reviews, saying, we are reviewing this. I had not filed an additional appeal. Perhaps that's part of their process. Perhaps someone else did. Perhaps the fact that, I posted about it, got someone's attention. I don't know for sure. But then I do know that again, a little while later, they said, "Oh, it was a mistake to have taken this content down," and they've now put it back up again. And so while I am both grateful for the fact that it's back up, and frankly, I think the fact that LinkedIn seems to be taking this sort of content seriously around these issues and trying to enforce their policies is a good thing. That said, this really does highlight just how non-transparent or opaque the process is. It's just never really clear what the guidelines are necessarily, how they fit, how they will be enforced, and what the appellate processes are. And so, as we move towards legislative reform to address some of these issues, it seems to me one of the core elements will be, or will there will be a need for greater transparency about what is happening. If we're going to say platforms are responsible, part of this has to be that the public has a better understanding and open knowledge about what, in fact, the platforms are doing.
Yeah, I think that's really important because you have the wherewithal and to understand you can appeal the process. But here's the dilemma, which is you put up a post that has hateful words in it because you're trying to highlight the fact that people are out saying this kind of thing, and you use a word like Holocaust. AI or whatever their algorithms, whatever they're using, has no ability to distinguish whether you're criticizing that and putting it in context and saying this is bad, or whether you're an actual promoter of hate and saying it because you believe it. Like, this is so fundamental.
Yeah, so these are really hard issues, and content moderation, which I do think there is a role to play for this, is very, very hard. I mean, I think this kind of highlights that, where you can have content that in isolation or without context might well be seen as violating a policy on hateful content. And I'm not sure if it was the reference to the Holocaust or the image itself, but I can understand why someone would reach that conclusion. When taken in totality, when you read the context, well, then you better understand that this is actually not hate, but an attempt to call out hate and make people aware of it. So I think AI systems will get better, but I also think that our policymakers need to understand that when they impose these obligations and say, hey, you broke it, you bought it, so to speak. You've got to find a way to fix this stuff, and the volumes are so large. Clearly, you're going to use AI. That these are very tough. This is very hard, and it means that there will be content that comes down that should not, as I would submit was in my case, and it means you then need to have processes in place to seek to address that. Doesn't mean that we shouldn't be proactive in dealing with some of the stuff. I think that part's fine, but what I do think is that we need to have far more transparency about what the processes are. And at the moment, even a company that is clearly trying in LinkedIn, and we could contrast that with X, which doesn't do anything, it seems, and certainly didn't do anything on this. I think I'm glad that they're doing that, but I also see I think the limitations of some of this becomes readily apparent once you actually go through the process.
So let's separate out. So that's kind of, to me, in the free speech category, which is what is really concerning a lot of constitutional groups and other people, saying this is going to have an impact on free speech, and that's what's troubling about it. So we'll come back to that. So let's look at the online harms and kids being harmed and what they've done about that, in terms the part of the legislation that you kind of like more than the other part. But there are real concerns there. When we go through the whole question of even being able to say that, I guess you would know, you're a lawyer, but the prior restraint issue, right? That the people that are going to oversee this are going to decide whether somebody might say something that's harmful or hurtful. The groups that get to decide about this, we're going to have czars appointed by government, senior bureaucrats. We're going to have a justice minister. This is not a timely response to this. If a kid's images are being used by pornographers online, and it's Saturday and we're trying to deal with the Minister of Justice or the Human Rights Commission, which also has a lot of problems as an organization, there's just not going to be any timely response, never mind anything else.
Well, there's a lot there. If you don't mind, let me unpack a few things, because I respectfully not sure that I agree with
Okay.
with all of that take. I would say first let's recognize that some of what you even identified, so the so-called prior restraint, for example, brings us back into that second bucket. That's the bucket where we're
Yeah.
dealing with criminal code and Human Rights Commission related stuff that's not in the issue of the platforms, because the Online Harms Act, I think we need to keep it in mind, is focused on what are the responsibilities of the platforms. That's not where you get into this notion of peace bonds or prior restraint. Okay, so here it really is focused. What are the duties and responsibilities of these platforms?
Right.
What are the kinds of harms that we want to have them focus on? And then how do we enforce? Essentially becomes the core elements. The harms themselves, and there are 7 in the bill, most of them focused on kids. So sexually victimizing children, bullying, inducing children to harm themselves. And there's extremism and terrorism, inciting violence, fomenting hatred, and intimate content without consent. That would essentially revenge porn.
Yeah.
And so those are the areas. Most of those issues, if not all those issues, I think most would agree, I think all the people would agree, all the issues are truly genuine harms. The question for some, I recognize, is that it may be tough to, what is the definition for some of this? For the most part,
okay, we'll come back to that because it's the definition, right? Yeah.
There are definitions, and they try to rely on criminal code type definitions and the like, and the standards can be, I think, fairly high. Some of them I don't think raise all those significant issues. Let's recognize that for the most part, there is not a requirement to remove content. That in fact, removal of content is limited only to two kinds of content: the content that sexually victimizes a child, or the intimate images content that's communicated without consent, the revenge porn. Those actually do act quickly and don't require the sorts of approvals that you just identified. So you're saying you got to move fast. The law actually agrees. And the law says that the platforms have to respond to that content when it's flagged and render it inaccessible within 24 hours. So they've got to move immediately to try to deal with that. And they've got a process in place where there can be appeals. For the other kinds of content.
But how do you do that? As you're in your own case, there you flagged it, you appealed it, there was a change of like that's not now.
My content is not the content that would be
no, I understand, but I'm just saying in terms of when you complain about it, when you file a complaint or an appeal in this case, and that's directly to the company, right? That's directly to the platforms. But if somebody's going to complain in other ways through other mechanisms that are being set up, that's could be more problematic.
Yeah, but that's not really how this is envisioned to function. Okay. The way it is envisioned to function is that the platforms have a duty to act responsibly, is the language in the legislation. That's really the core element. Now, that's a pretty flexible notion. And in some ways, some might say that's a feature, not a bug. You want to ensure that you can adapt what it means to act responsibly depending on the circumstance. And so let's say AI becomes more and more of a concern in terms of AI generated content that falls within one of those baskets. It may be that the expectation of how you would act responsibly for that kind of content differs from, let's say, genuine original content. In any event, the duty to act responsibly includes having certain functionality on your site. So, for example, the ability to flag content for your users to flag content, the ability for your users to block other users so that they can avoid having to deal, let's say, with bullying or some other kinds of things, and to develop a digital safety plan of how you intend to deal with this. Where we get an interaction directly between the commission and the company is in large measure, at least initially, around developing this plan. It's essentially the company saying, okay, here's what we do. And here's what we anticipate doing in these kinds of circumstances. And so we'll have more transparency. They'll be required to disclose much more about what has been taking place. And you'll have the commission reviewing that, saying whether it's sufficient or not, and taking in a lot more data. There will be an ombudsperson that's available as part of this system that if you're unhappy with how this was dealt with, if, for example, my content came down and never went back up again, and I felt I got it wrong, then in theory, I could seek to use this system to sort of address these issues, either because they took it down and they shouldn't have, or they didn't take it down and I thought they should have. So there is that possibility. But I think the hope and expectation is that what this legislation is trying to deal with is to create a framework whereby the platforms are simply held far more accountable. that rather than being in a position where they might do something or not do something, and we're not even sure what they've been doing, now they're going to have to be much more upfront. And there's going to be effectively a review, not by the government, but by this commission about what it is they say they're going to do. And the commission will be able to be in a position to say whether it goes far enough and say, you know what, that's fine, but here are the additional things that I'm going to require you to do to approve this plan.
It always comes back to this, unfortunately, quite subjective interpretation of what's hateful, what is abusive, what is making somebody feel uncomfortable, what is it? That's in the eye of the beholder, and also in the eye of the ombudsman or the people that are going to arbitrate this. It's hard not to bring your personal standards or even politics to the table, right? And as we see on the Israeli Hamas issue, right?
Yes, but bear in mind that first off, there are 7 harms here. Not all of them fall within that list at all, right? Where there are those difficult judgment calls. I'd argue. I don't think that it is that hard to necessarily get into some of these questions around sexually victimizing a child or inducing a child to harm themselves. I mean,
that's pretty straightforward. Yeah.
Yes. So, and there's also, of course, the terrorism one. I mean, we've had laws on the books that deal with terrorism for some time. I don't see why that would be particularly challenging. The ones that I guess attract more attention, of course, are inciting violence and fomenting hatred. They've provided language. They are relying on court cases that have sought to identify that. And of course, there is appellate processes put into place that will allow, if there are different decisions that are made, to challenge some of these things. Is there a risk that stuff is either included that some might think should not be included, or not included that people think should be? Of course there is. Yeah. But I don't think that is necessary. I don't think that's a fatal flaw of the legislation. The question is this a significant enough harm that we think that there is a role for legislation? We clearly do think that, because we have legislation that does deal with hatred and with inciting violence. And so then you get to this legislation, and then your question becomes, is it enough to say law enforcement needs to deal with this? Or is there a role for the platforms that may at times amplify that, fail to take action, and so are part of the harm, in part because of the role that they play and the power that they wield in terms of how people may access this? And this legislation essentially reaches the conclusion that says, yes, there is, as many other countries have concluded, there is a role for the platforms to play, and this seeks to put that out. Let's note that earlier versions of this envisioned mandatory takedowns of all sorts of different kinds of content, mandatory reporting to law enforcement, blocking of websites. We've had some call for age verification. All of that stuff is not included here. So, I think they've come up with a much more narrowly targeted piece of legislation that on the online harms piece, I think they've identified harms that most would agree with are harmful. And they've, I think, tried to find a way to deal with it. I think there are issues. I think, frankly, I have greater concern with the powers that are wielded by the commission than I do with the framework that's been established. So I think there's room to improve, but we're coming from a much better starting point than we might have otherwise expected.
Some have argued, and I think we've seen it in some cases, that there are laws on the books already on things like hate, but they're not enforced. So, or often they're not enforced. A woman who's suffering revenge porn, goes to the cops, and it's kind of, well, what can we do? Like, you explain to us why this is hurting you, like change the channel, shut this off. So have we made any serious, well, I think both you and I were listening to Beverly McLaughlin, the former Chief Justice of the Supreme Court of Canada, talk about this recently. And, she said part of the problem, even with the legislation that already exists, is the definitions are a bit of a problem. They're loose for a reason, which you have cited. You don't want it so stringent. But on the other hand, it makes it hard to deal.
Well, yes, of course, there's always going to be some of those challenges, and there could be ultimately challenges at the courts, as I thought former Chief Justice suggested. I think it's clearly been the case that we have not seen law enforcement do enough, I feel, when it comes to certainly some of the kind of hate that we've seen over the last number
Yeah.
of months, and whether or not they have been positioned to act against some of the other harms or have acted against some of the harms in the way that as aggressively as we might otherwise hoped, I think is certainly a subject that we can get in, that you can have debate on and might well reach some conclusion that they haven't. I'm not convinced, though, that's a reason not to do this legislation. In fact, I think you can make the case. I think the reverse. I think the fact that it is very tough to get the kind of prosecutions or law enforcement work that we might generally want to see take place is itself actually the exact reason why we would want to see this kind of legislation, because the law seeks to go after the perpetrator of this. And of course, we want to go after the perpetrator. But what I think we also want to see happen is try to ensure that, in fact, that we mitigate against the harm to the maximum extent possible. And going after the perpetrator, which is obviously a very lengthy, difficult process, doesn't really mitigate in the moment the harm that is taking place. This legislation is designed to do that. And so in some ways, I think they're complementary. And the fact that we haven't seen the laws exercised as effectively as we otherwise have hoped, actually, to me, is evidence of why we would need this kind of legislation.
But here's my, I agree that the platforms should be doing and can do a lot more. They're kind of the transmitters, the middle guy. But if you're not dealing with perpetrators and you're putting all of the emphasis on, we're going to stop those big bad streaming services and companies from sending this stuff out and having it viewable, like that's an important piece. But if you're not sending the right signals on the other side, if you're letting the protesters spew hate or write whatever they want on the walls or engage in child pornography and you're not doing anything about it, then, that we're dealing with the horse already being out of the barn.
Yes, but I don't think we should have to choose.
I don't either.
I totally agree with you. I think that I think there needs to be a much clearer commitment to using and exercising some of the existing powers that we have where these things take place, and whether that's law enforcement or whether that's the Crown's office. I'd like to ensure that, that if there's revenge porn or if there's these other sorts of issues, of course, apply the laws. But I think alongside that, let's ensure that let's I think recognize that there is a role for everyone to play in dealing with what I think are legitimately recognized harms, and those recognized harms in this instance do include some of the kinds of things identified in the law, and the platforms have a role to play. And I think it's fair to say that at least to date, the platforms have been at best inconsistent in how they've been addressing those issues.
Okay, then we get to the other larger issue which people have raised about this bill, and I think you did too, which is, Human Rights Act provisions, criminal code, like maybe that should be separate from a discussion about what we're doing to save kids from this ridiculous, unnecessary, hurtful, dangerous content that they can see. But in fact, these things are pretty key to how the government seems to see this, in terms of how you go ahead and complain about a lot of things, about what punishments might be. Some of this stuff is very serious in terms of life imprisonment and huge monetary fines for the middle guy, right? For the platforms would be paying these big fines if some horrible human being is saying and spewing stuff which happens to end up on their platform. Like I'm still struggling with this.
Okay, well, let me break it down, because again, the part I think
I know it's not just the kids; it's all of it.
No, but it's not just that. There is confusion even within this legislation. I think the government is partially responsible for the way they've put this forward. The platform penalties are not at all related to the criminal code penalties or Human Rights Commission stuff. It's just not. Platform penalties are related to that what we talked about earlier, digital service, the digital safety plan, those issues, if they fail to comply with what they have said they would do, then they face or fail to abide by an order that comes from the Digital Safety Commission. That's where penalties come to the fore, not on a particular piece of speech.
Failing to comply is still the transmission of the questionable, appealable piece of content.
But it's not. It is the failure to abide by the digital safety plan that you established or an order that comes from the commission. So it is not looking at a piece of content and saying you're liable for millions of dollars because you didn't take this down. That's not how this is designed to function. It's designed to say you face liability because you failed to meet your duty to act responsibly. And here's what you identified you would do as part of that. Now, there are also penalties, as you mentioned, this notion of life in prison that we see in the criminal code, for example, or the prospect of individuals using the Human Rights Commission to bring complaints. Those are separate. Those are not platform focused. I think they do raise concerns. I think the criminal code penalties are, frankly, impossible to justify. They really don't make any sort of sense. I don't think that they are the big part of the bill. They are not. They're actually a pretty small part of the bill. And I think the government would do well to remove that and ensure that the focus is on the platform related issues.
Okay, but that's kind of core to that second part of the bill, and that's where we get into the trouble, which is separate from doing the right thing when it comes roughly to kids or vulnerable women or vulnerable people. And then this other stuff about who decides what is acceptable content online.
No. The criminal code stuff does not get into that again. Sorry, respectfully. Criminal code stuff is not getting into those questions at all. Criminal code, that idea of life imprisonment, is if you had a crown bring a case against someone on some charge and they say that there was a hateful motive as part of that, that's where that gets invoked. It's not about saying something. It's about other criminal code actions that then have a hate component to it. I still think that you simply can't justify the penalties that are there, but that's what the criminal code side is.
I don't know how you're... Sorry, go ahead.
The Human Rights Commission elements, which are the part that does get you into the speech-related sources of concern, right. And I think that there is stuff. Now, that is not platform-related. That's where you communicate hate speech. It does not include, I should note, linking or private communication, but that's where there is the ability for someone to bring penalties. This is not the government now. This is individuals bringing cases under the Canadian Human Rights Act, complaining about communication of hate speech. Again, not a private conversation, but something that was done publicly. And then there are penalties that are large that the Human Rights Commission could become involved with. That somewhat infamously has been the ping pong provision of Section 13 was in, then it got taken out and put back in. This would put it back in again. I think that it does open the door to a large number of complaints. Some might be legit, some not. I don't think that, to me, this is the most effective way of dealing with these issues. But I also don't think that this is reasonably viewed as sort of a widespread government deciding what you can say online or not. I don't think it amounts to that either.
Well, no, I mean, of course, that would never be something that was publicly declared anyway, for all the obvious reasons. But it just seems to me whether the government has confused the presentation of this, and whether they've done it accidentally or deliberately or due to some competence issue. There's so much potential crossover. I know you're making this distinction about, the crime itself is over here, and it's only whether or not the companies complied with the rules they said they would follow. But you're also dealing with what is online. I don't know whether that's just a question of confusion or not. I'm thinking it's when I read all of this stuff, I just go, there is a way to go in the back door, maybe even the front door in a lot of these cases.
Well, I would say that it's not me making the distinction; it's the legislation that makes this, but that's important. It's the law itself is making distinctions, and and at the end of the day, that's what I think that we rely upon. In terms of why it's there, I must admit, I don't think there's a nefarious reason behind it. I think that it simply reflects that there have been a number of community groups that have been actively pushing for these provisions for some time. And,
Yeah.
in some ways, and this comes from across the spectrum. I mean, they're respectable groups, and they've been fighting hateful related issues for a long time, and say that they believe that these are some of the kinds of powers that are needed in the arsenal to deal with online hate. I get that. That would be where that's their focal point. I guess, my view of that would be, first, that I think where the government did best on this is the legislation that is less directly connected with any stakeholder pushing for a particular outcome, and more a genuine effort to develop the best possible policy process. They had an expert committee, and I feel like the online harm stuff comes closer to the mark in that regard. And then, frankly, I would say to the groups that have been pushing for this, that, in my mind, it's in their best interest, and it's, again, everyone's best interest, frankly, to separate this out. You want to bring forward those other provisions and in a separate bill and have the debate, that's fine. But if you believe that the government's has a pretty good starting point on the online harms piece, have it go separately. And I think that you can have a more fruitful debate without some of the kind of confusion that you've referenced.
Do you have any sense? I mean, as you quite rightly point out, they have tried this one over the course of the last 3-4 years, and put it out there. They have done their consultations. They've certainly heard from the public in spades by going through the other pieces of legislation that were different but not unrelated. So they've heard it, and this bill was still put forward in this form. So they must have come to that conclusion that they want it together.
That could be, but listen, I must admit, to me, my primary takeaway is not that. My primary takeaway really is that we spent many hours, frankly, talking about the government's false starts and poor starts on C11 and C18 and the internet regulation, which seemed to me to be driven much more by stakeholder interests as opposed to good policy development. And I think, in fairness, this is the third element of that, and the parts that deal with the internet, frankly, they've done a much better job. I mean, I don't see, that it genuinely, when you compare from where they started and how they approached other things, there's a pretty significant difference.
But here's my question to you, because is it worth the price to get what you think is a much more reasonable approach on the online harms piece about the kids, if we can do that, if the other part has to be attached?
Well, I think we need to fix the other part quite clearly. And, even as you mentioned, former Chief Justice talked about it. I think, frankly, life imprisonment is provisions that would never be sustainable anyways. Mm-hmm. So frankly, remove them now or remove them later if they ever get used, because they'll get struck down. But I do believe that there are real issues here. Yes, I mean, this is online harms are real. Yeah. And leaving it exclusively to law enforcement is not effective and does not deal with this issue on its own. And so there is a role to play for platforms. And we do have enough experience to know that, left to their own devices, platforms on their own have not shown themselves up to with an ability to meet that challenge.
Okay, so then the next question, as we sort of, take an overall look at this, is the structures that they're putting in place, whether it's the use of the Human Rights Commission or the Ombudsman or appeals to the minister or whatever, those kinds of processes, are those things that you think could work?
I think the system as a whole could work, but I think the current structure is one that requires some change. And to me, the big concern I have with the Digital Safety Commission, and I guess with the caveat that we need an enforcement system. There has to be someone that enforces this. You don't want the government enforcing this for obvious reasons, because it does have implications from a speech perspective. I don't think you want the CRTC regulating this either. This feels like a commission already having to often dealing with issues that
they're
fall
kind of
outside.
busy.
Well, they're busy, and I'm not. Again, I don't. Much like in some of the other areas, I'm not convinced they've got the expertise to deal with this, and I don't think they would have the public confidence to deal with this.
Right.
So I think we do. I think it is reasonable to say that we need a new entity to deal with this, because there needs to be some mechanism to deal with it, and the existing entities we have are not really fit for purpose. So I appreciate that, but if you are going to have a new entity, I think you've got to structure it in a way that builds public confidence. I think you've got to ensure that there's appropriate oversight. I think you've got to have appropriate limitations and powers. And I'm not convinced that, as currently structured, they've done that with the Digital Safety Commission.
What kind of system, give us in 30 seconds or a minute, your view of what that structure would look like in your, if you were designing it?
Right. Well, you could call it the Digital Safety Commission. It's still that. I think there needs to be more commissioners with a wider range of expertise. The moment the law talks about 3 to 5 commissioners, I frankly don't think that's enough to take into account the sort of expertise you'd want, both in terms of people who have expertise in some of the kinds of harms we're talking about, and privacy, and freedom of expression, and some of the technical issues and the like. So I think we need more people involved. I think there need to be some pretty significant limitations in terms of some of the kind of order-making power, and even some of the investigative powers, at least without court oversight, that they may have. And then I think you need to ensure that there is someone essentially that watches the watchers, that you've got some oversight mechanisms that exist on top of this body. And we can look to other examples. This seems to be drawn from the Australian model, because the Australians have created an e-safety commissioner, and it's been in place for some time. But there are differences, and the e-safety commissioner has fewer powers than what we see here, and so there's been more limitations established. And I think that's more appropriate, and frankly provides us with a better sense of what an appropriate model might look like.
Okay, but that is still a pretty cumbersome. I'm just trying to get from you a sense of timing here about how these structures work. I mean, in advance, you want people to have a basic set of rules about what constitutes online hate, or what constitutes genocide, or what constitutes revenge porn. You'd have to have some pretty significant definitions, because I agree, while you need a lot of other people with expertise in particular areas of assessing that and judging that, you can't do that on a case-by-case basis, or otherwise the timeline just stretches out forever and a day.
No, again, the structure is about establishing framework policies for these companies. It's not, at least initially, about trying to deal with one-off pieces of content. So you can't, in those policies, develop exactly the answers that you're looking for. The law already does provide. The law provides pretty specific detail with definitions about what each of those things are. We're not saying that a Digital Safety Commission just makes up, let's say, I don't know, what it means to incite violence. The law specifically tells the commission what that means. Now, and they draw, of course, on either the criminal code or on case law to do that, and they do that for each of these different areas. We're not starting from scratch here. And once you then create the digital safety plans, it then embeds those definitions within those policies. I don't think that's where the challenge lies. I mean, I think that we can, of course, there'll be differences of opinion as to whether or not certain pieces of content, let's say, apply or don't. But that personally, I think that's okay. Of course that's going to happen. There's always going to be some differences of opinion. That's why you have a system in place to deal with it, and appeals and the like if needed. But if we can create a system that deals with the majority of the harms in a more effective manner than we're dealing with now, then of course, let's take the time that we need with appropriate processes to deal with the edge cases. But where we're dealing with non-edge cases, and there's an ability to try to mitigate against the harm, it's not clear to me why we wouldn't want to try to embrace that either.
Yeah, I think the part of the problem with this is, and the concerns that have been raised, and you're quite right, this is framework legislation. But as we've seen in other pieces of framework legislation, that means once it's agreed to, it goes off into the the bowels of the bureaucracy, and it's all worked out with regulations and rules that are done not in the with the light of day shed on this. So I know this is getting a little bit too much inside baseball, but I'm just wondering how we can, because this discussion also needs to happen in the public at large. You know, that's part of the reason you have debates around legislation, is to engage people and bring it in, not put it in the back room and say we'll sort it out in, you know, later behind closed doors where it's not so complicated.
Right. Well, of course, but and actually most of the regulations, the ones that matter the most, are not established by government. They're established by the Digital Safety Commission. So it's not the government imposing this. It's actually the commission itself that would establish some of these codes and the like. Yeah, I think that it would be a mistake to go in and sort of adopt a pure trust us approach. But you know, that's not what I don't really read with that being that's what the legislation says either. I mean, there are regulations, and frankly, as I say, most of the regulations and the specifics you're talking about are not going to be coming from the government. They come from the Digital Safety Commission, which is this arm's length body with separate people appointed.
Yeah, again, dancing on the head of a pin here, but I mean, we've had this very discussion about the CRTC. If you're appointed by the government of the day, you know, how do you create these structures that kind of have the flexibility to change and respond to changes that we see in society or activities that are going on in society, and people who would just become another CRTC with 5 or 7 year appointments and don't have that ability to respond in real time or reflect a change in public opinion, or even for that matter, government.
Yeah, I mean, I do think there are differences between, and I say this as someone who has identified the commission as being, at least in terms of the broad structure, is one of the sources of concern. But you know, this is not the same as the CRTC. I mean, CRTC, we've had real concerns around regulatory capture and those kinds of things. This is not that. I mean, this is I'm not aware of regulatory capture around child bullying or around revenge porn. There's not an industry there that is going to be seeking influence on the stuff.
No, there won't be a lot of lobbying and
no. So I mean, could you have? Of course, you can have people there that have differences of opinion that we might differ with in terms of how they interpret on some of these issues, and that's frankly why you need appropriate oversight of the commission and the courts involved, where there is disagreement on some of the steps that should there be disagreement on some of the steps that they take.
All right, so this is going forward. What's your expectation of process here? I mean, everybody is looking eyes out to an election sometime, maybe 3 months away, maybe a year and a half. Do you get the sense that they're going to move on this really quickly? It kind of looks that way because they want it in place, or is this really about just engaging in some public debate?
Well, listen, it's a great question. I wish I knew the answer. I think we could safely say you are not going to see it in your committee or at the Senate for a while. It's going to take a while to get to the House, through the House. You know, I think that if you look at the calendar, parliamentary calendar, it's going to take a bit of time. We're going to have a budget in April, so it's going to take some time before I think a committee gets serious about it. And once a committee does dive in, this feels like the sort of legislation that's going to take quite a considerable amount of study. There'll be a lot of differences of different opinions. So, you know, it seems to me that this is going to take some time. If we have an election in 3 months or in 6 months, well, that's pretty clear that this legislation is not going to pass before then.
Right.
Is it possible, though, that if the government continues to govern until essentially the very end of its mandate, let's say until the summer of 2025, could this get through that process in that time? I think you could conclude that it does. So I think there's some amount of uncertainty. I think there remain about its prospects. I would say that I think many are looking at it as saying they're not sure, but there's enough of a real possibility here that you need to ensure that it's properly studied and your voices are heard on ways that the bill can be improved.
So I'm in part, and I'll leave it at this, but I guess what I'm asking is, given the history with the this government and legislation and the platforms themselves? Do you think there might be some action on part of the platforms, knowing this is coming, if doing some things that might help or appease or preempt or at least deal with the problem?
Well, I think the platforms would say they are, and I think many people would disagree or say they're not doing enough. I don't expect to see the platforms oppose this legislation in the same way that, let's say, we saw in C-18, because I frankly don't think that, well, for a couple of reasons. First, I don't think that they would be of the view that the kind of harms that they're dealing with are things that they want to see on their platform either. So I think that they would be of the view that they're happy to try to deal with this stuff. And I think where there may be disagreement is on what they're doing and what the government would say through this legislation they need to be doing, and saying that they're not doing enough. So I think that, or at least I would hope that that this is a more constructive consultation and policy effort, because it's one where I mean, there's some who will clearly oppose with good reason the criminal code and the Human Rights Commission stuff. The core stuff with the platforms, I think there will be any number of issues identified, ways to improve the bill. And my hope would be, you harken back to the earlier bills, my hope would be that, unlike some of those bills where, it was seen as a kind of, you're with us or you're against us. And this would be one where there's a more open, there's greater openness to trying to be constructive in trying to deal with some of these issues. I would hope that there's a bit of that. And I would also say that we ought to recognize this is not happening in isolation. There are similar kinds of rules developed in Europe, in the UK, in Australia. And so if you're a platform, it's not like you're coming at this and saying, well, Canada's just completely offside. We've never seen anything like this. There may be some provisions that are more uniquely Canadian, but there are going to be any number that are ones that you've seen variations on from other jurisdictions.
This is great. Thank you. I'm glad there are people like you that remain so optimistic about this stuff, and that there is hope, and that governments will listen to people, and that it will all come out in the wash. I really, really, really hope you're right. But it is complicated, and thank you for your patience in terms of walking us through this. We trust your judgment, so thank you.
Oh, absolutely. Thank you so much for having me.
That's great. Michael Geist, law professor at the University of Ottawa. He is the Canada Research Chair in Internet and E-commerce Law, and writes and talks and comes to Senate committees and testifies on this stuff all of the time, and we're very grateful that he does. Thanks again, Michael. Okay. And thank you all for joining us. We'll see you again very soon for another edition of No Nonsense with Pamela Wallin.